wanted to talk about also the Justice Thomas concurrence, because when we spoke about the draft opinion, we mentioned how this was very dangerous for a number of reasons, one of which it could lead to other rights being overturned as well. And I talked about the right to contraception. I talked about interracial marriage. I talked about gay marriage. I talked about private consensual relationships. Justice Thomas basically said that, right? He said, well, we have no substantive due process anymore, meaning we're not going to interpret the due process clause of the 14th Amendment to include these liberty interests such as abortion. Well, all these other rights, which were landmark cases, were decided with that same reasoning. So if we're going to undo abortion on these grounds, that allows us to undo all these other rights on the same grounds. That was a big part of the danger in reading the opinion. Yes. Now, this was a concurrence that Justice Thomas made, meaning he agreed with the result, but his reasoning was different. He actually went further out on a limb and went even more crazy than the majority did. So they don't agree necessarily with his reasoning. Really, in the majority opinion, they didn't outright say there's no more right to privacy and all these things have to fall. But there is that door opened now to go down that path and do a similar type analysis. Justice Thomas is saying, hey, we opened this door, we should just get rid of all these things. I did mention previously the equal protection component, which is another layer of protection constitutionally that some of these issues have that others don't. So abortion didn't have the equal protection component because it wasn't about discrimination. At least that's not how the court interpreted it. Contraception also falls under that category. It's either you could do it or you can't. But when we start getting into marriage, for example, or even having whatever kind of sexual relationship you want with someone, you start getting into this equal protection aspect, which is the law says, the Constitution says, you can't treat certain groups of people differently from others. So if the court tried to overturn, for example, gay marriage or interracial marriage, it wouldn't just have to deal with this due process issue. It would have to deal with the idea of, well, wait a minute, how could you tell some people they can get married but not others? However, we see now the court does what it wants, right? It can overturn itself. So we shouldn't say, okay, we're confident it's never going to change. No, they could change it. But I do want to be intellectually honest and say that the abortion decision doesn't automatically knock down those other things because there are other barriers in place that will keep them in.
Wasn't one of the arguments that they made was that, okay, well, this isn't going to apply, even though we're using the same reasoning, this isn't going to apply to other things because this is a special case. But right now that the actual decision is out written, Thomas is like, yeah, it's not really a special case. It can apply to some of these other things.
That's exactly it. The majority opinion is saying, hold up, we're doing all this constitutional dancing here to reach this conclusion about abortion, but don't read into it too much because we really just don't like abortion. Thomas is saying, no, I like the dancing you're doing. We should do that same dance on these other issues.
Right.